My goodness, we have a crowd. Good morning. A couple of things to note before we get started. We live stream all these arguments now. So just remember, whatever you say goes out to the internet. And, what goes on the internet stays out there somehow. I don't know how. We have some interns from Davidson County Courts here today to see us, and we're always glad to have you. And after court, we will visit with them for a few minutes. So when we adjourn, we won't leave. We'll just stay here, but you can leave. And finally, for the appellants, please remember when you come up and introduce yourself, if you wish to save some time for rebuttal, up to 5 minutes, please mention it so I won't have to interrupt you and ask. Are there any announcements? No announcements. Would you call the first case, please?
Constance, Lynn, Bennett as the personal representative of the estate of Jennifer Diane Vickers deceased versus Diversicare Leasing Corporation et al.
Whenever you're ready.
Thank you. May it please the court. My name is Mark Cole, and I'm associate with the law office of Louisville Glanton. We represent the appellant Constance Bennett, the personal representative of the estate of Jennifer Diane Vickers in this medical malpractice action. I'd like to request 3 minutes of my time be set aside for rebuttal.
3 minutes, okay?
Thank you. Mrs. Vickers, the facts of the case are Mrs. Vickers, the original plaintiff, was in a nursing facility owned by one of the defendants when she had dental pain. The facility called Dr. Paul Strawn, who's another one of the defendants, who worked for One Care Dental Solutions, which is another defendant, and came out to the nursing home. Dr. Strawn did not read the medical record of Mrs. Vickers or ask what medication she was on. He didn't even talk to her about it. If he had, he would have learned she was on both anticoagulants and high-dose aspirin. Instead, he decided to remove 18 teeth, some of them surgically, which caused Ms. Vickers to bleed so badly she had to go to the emergency room. Ms. Vickers contacted legal representation, proper notice was observed, and the lawsuit was filed with a certificate of good faith. During discovery, it was determined the plaintiff actually had a cause of action for implied consent, and amended complaint was requested and to the court and was granted. We filed an amended complaint, but certificate of good faith was not filed with that.
The lack of informed consent claim here, that was against the same defendants, right, who had already been named in the case? Okay.
Yes, Your Honor. No change of defendants, no real change in any of the factual situation. Another certificate of good faith was not filed with the amended complaint. What happened here is that we had placed in the new complaint that we had already filed the certificate of good faith, because as I understand the statute, that it said for the complaint, for the beginning of the action, a certificate of good faith was necessary. It mentioned that we filed previously. Additionally, the amended complaint did not give another 60-day notice too. The appellants filed a motion for summary judgment, and in our reply to the motion for summary judgment, we gave them the affidavit from the doctor that said there was a good cause for implied consent. The trial judge in the case, this is Judge Atwood in Murfreesboro, held that the filing of the affidavit of the expert was insufficient for good faith, and she dismissed the case with prejudice. The case was appealed to this court, and it was heard on April 5th, 2022. This court held that each party had offered a reasonable interpretation of Tennessee Code annotated 29-26-122. Additionally, this court stated that the statute is silent on amended complaints. However, the court also stated case law has established that amended proceedings need to have the certificate. The appellant argued that the amended complaint included a notice that the certificate was previously filed and should have been sufficient to cover the new claim. The court held a new amended complaint needed a new certificate of good faith. The court did reverse the trial court's ruling that good cause, as the judge had applied the wrong standard of extraordinary cause, as opposed to for time to file a new certificate of good faith. The court did vacate the dismissal of the amended complaint in its entirety, and just instead of just the informed consent, and remanded it back to the trial court on remand, and ruling from the bench immediately after oral arguments ended. The trial court stated that even though the plaintiff stated there was a misunderstanding in statute and requirements, this court has found that it's not good faith that the statute's language is clear. The trial court held that the plaintiff appellant had noticed that the affidavit before she filed the amended complaint, and the trial court further stated there was no misunderstanding as to the need for filing a certificate of good faith. She specifically stated she did not receive specific reasons prior to and did not hear any new ones that day. She said the court had needed new information.
So, counsel, is it your position that the trial judge here just simply misread the law in ruling on the motion for extension of time on remand?
Well, that's an interesting question, Your Honor. I think, I don't want to say the judge did anything wrong, but I feel that the purpose...
Well, you're going to have to say...
Yes, Your Honor.
Abuse of discretion here.
I understand. I appreciate that. Thank you, Your Honor. I think she misread the law, Your Honor. And I think that she held the wrong standard, extraordinary cause, as opposed to good cause. And she also, from reading the transcript, it appears that she was ready to go and already, and it was felt by the appellant that she had already made up her mind on that. And so in that, what happened there is that she again dismissed the complaint.
Is the misreading here, counsel, that Groves and Serbaugh involve new defendants, and that this case, what Vickers 1 involved, is essentially a new claim as the same defendant, and that that's the variance, and that the trial judge here instead viewed those as being identical circumstances, whereas this court in Vickers 1 described the question as unsettled in its language and sending it back to the trial court. Is that a fair description of the misreading in this case?
Yes, Your Honor, I believe so.
So we've often said that misunderstanding of the law may be good cause. We've never, ever said that it is or always will be good cause. So how could we necessarily say there was an abuse of discretion here?
Well, my understanding, this court has said that if the statute's clear, there is no misunderstanding. However, I think the statute is not clear, and the reason being is there's so many cases in front of this
I guess
court.
my point is, let's presume that the court was wrong, but there was a misunderstanding. That doesn't mean de facto that there's good cause, does there? I mean, we've never said that in our opinions. We've just said that may be good cause in a certain case.
Yes, Your Honor, but in this case, there is good cause, because I believe in the dissent in Allen versus Denner, that the statute is clear, and it does not say amended complaint, and amended complaint needs to have the certificate of good faith. It does say that the statute later on talks about amendments, but it doesn't say anything in that statute, and other statutes do talk about complaints and amended complaints. And it's my understanding is that the purpose of the statute and purpose for the notice of good faith for the plaintiff to show, yes, we have an expert take a look at this, and this shows that this case is not a frivolous lawsuit and one should go forward.
Well, shouldn't that apply to each cause? And when you add a new cause, doesn't that require a new certificate?
Well, that's apparently what this court had decided now, Your Honor, and I think if it's a substantially similar new cause, I think that should stand forward. However, if this court finds that yes, that is the case, that it needs a new certificate of good faith, we ask that we be able to file one, because one was done at the start of the case, and we ask that one be able to file this time, or we ask that this court, I believe this is in the dissent, the court held that, or the senator held that he would have dismissed the amended complaint and go back to the original complaint, which was properly certified.
Let me ask you about that. There are two issues that went back here, right, on remand. One was, is it good faith or is it not? The second was, is the entirety of the complaint dismissed or just the new claim as to which there is no certificate of good faith? Can you touch upon, let's assume, I know you're making the argument that your claim as to informed consent should survive. Let's say you're wrong on that point. Why do you still prevail with regard to the remaining claims in your view? And what's your contention for why the original claims that would still survive?
The original claims had a certificate of good faith with it, and all the hoops had been jumped at that time. If the appellees state that when you file an amended complaint, it destroys the former complaint, and we actually incorporate in the amended complaint the newer complaint. Now, if the court feels that the implied consent is no longer valid because we did not file the certificate with that one, we're more than happy to go forward on the other, because the other one was not perfectly filed, but substantially was filed in accordance with all the statute, so it should go forward. But if this case is totally dismissed with prejudice, this doesn't allow the plaintiffs to have their day in court. And the whole purpose of the statute, in my understanding, is to weed out frivolous lawsuits, and to I believe it was to help the healthcare industry when they're having to fight all the frivolous lawsuits, and to help the public at large. And this is not helping the public at large, because this is a case and it's basically being thrown out pretty quickly, pretty easily, as a lot of the cases that I've read that are regarding the certificate of good faith. This court found that there was nothing that said that the appellant acted in bad faith, and that we felt like we should be able to go back to the court and show that it was good faith, because the statute has been interpreted different ways, and this court in Vickers said both interpretations are legitimate. That's the wrong term, but both of them are reasonable. And because both of them are reasonable, it's clearly unsettled. I'm sorry, I was told never to say clearly in court. But the thing about it is, Your Honor, this is a case where this lady needs to have her day in court, and to be thrown out on something like this when she had done everything totally correctly in the very beginning. I can understand throwing out the amended complaint if this is what the court decides to do. But then we should be able to go forward on the regular complaint. And if we go forward on regular complaint, then she can have, win or lose, she can have her day in court. And that's what we're asking. And, I believe that that the dissent in Allen versus Denner, and I'm just about out of time. Thank you, Your Honor.
Thank you.
Good morning, Your Honor, and may it please the court. My name is Joshua Cumbie, and I'll be arguing on behalf of the defendant appellees this morning. When the allegations change to claim liability based on different facts, a new certificate of good faith based upon an expert's review of the newly alleged facts is necessary. That's what this court said in Colburn in 2013. And that's what it said when it decided Serbaugh against Vanderbilt in 2014. 6 years before the plaintiff in this case amended her complaint to add a new implied consent claim based on 30-odd paragraphs and subparagraphs of new facts, all without attaching either an old or a new certificate of good faith.
Counsel, is there any authority you can point us towards of a pre-Vickers decision in which there is a new claim asserted as to the same defendant, in which this court had concluded, or the Tennessee Supreme Court had concluded, that a new certificate of good faith was required? I mean, certainly required as to Vickers, it's law of the case in this case, but is there a case, I mean, Groves, the trial court relied on Groves, but in Groves, there's a new defendant that's being added with regard to the claim. Is there any authority pre-Vickers in which we have a new claim against the same defendant and their certificate of good faith is required?
Not a case decided by this court or the Supreme Court, Your Honor. But the holding that I just read from Groves and Serbaugh is not limited to the facts of those cases. Tellingly, in Groves, the court said if you add a new claim for physician liability, because in that case it was a doctor that had been added as a new defendant, then you have to have a new certificate of good faith. And
So what I hear you saying is that in the state of Vickers, I mean, I'm looking at it right now, we spend 3 pages of analysis on the question of how to properly interpret the statute. And I mean, basically what I hear you saying was that was all unnecessary. The idea, as we said in the opinion, that we find each party has offered a reasonable interpretation of the statute, not true, not true. In fact, there's only one reasonable interpretation of the statute, and we could have summed it all up in 2 sentences.
I think that all of the parties and the public appreciate the thoroughness of the court's opinions and its willingness to engage in the analysis required to reach its decisions. But respectfully, Your Honor, I think you could have put this to bed last time around with Groves and Colburn. And ultimately, that's where you ended up. You ended up in the same place. But the question here, sorry.
One of the sentences in here. So, although plaintiff and defendants have offered reasonable interpretations concerning the unsettled requirements of section 29, 26, 122, when an amended complaint is filed that does not add new defendants. And didn't this court say in Vickers 1 that it was an unsettled question? And the trial court, I mean, Judge Clement's opinion seems to say it's unsettled. The trial court judge seems to have said, well, wasn't really unsettled, but isn't the court pretty clear that this is an unsettled question?
Well, the court twice in its opinion said that the parties' interpretations were reasonable, and the parties appreciate the court's courtesy in that respect. And you're also correct that the court said that it was unsettled. However, those were acknowledgments, they were comments, they were not necessary to the holding in Vickers. And just because this court acknowledged that there were reasonable interpretations or diverging reasonable interpretations, and even maybe acknowledged that there was some unsettledness in these interpretations, doesn't mean that this court found as a matter of fact or law that the statute was unsettled or potentially confusing or unclear. Because if the court had found that, then it could have also disposed of the question about good cause for the extension. But it didn't do that. This court remanded that question to the trial court. And the trial court, based on Groves, based on the facts of this case, which I would like to discuss a little bit, decided in its discretion to deny the motion for an extension of time to file a new certificate of good faith.
I'm trying to think about that point. So part of your argument here, and correct me if I'm wrong, is, had it been a straightforward, surely you grant the extension here, the Court of Appeals should have done that.
It either could have done that, Your Honor, or it could have remanded with instructions to enter an order granting the motion for an extension.
And I guess my question to you then, is that the appropriate role for the appellate court? I mean, normally we let the trial judges make the discretionary decisions after advising them of what the law is on the correct report. And of course, on this one, we had another issue, which was the standard of review, or the standard that the judge should apply in considering the extension, because there was an extraordinary cause component applied in this case.
Correct. And the trial judge first time around applied the wrong standard, and the court sent that back for reevaluation, but didn't necessarily need to do that if, as a matter of law, this was an unsettled area of law or potentially confusing. Because again, if that finding is made, then the good cause necessarily follows, and then there's nothing for the trial court to do other than enter an order based on the instructions given by this court. So that's why I say that those comments are what they are, but at the same time, this court did not resolve that this was an unsettled or potentially confusing area of law such that there was then, ergo, good cause for a motion to extend the time in which to file a new certificate of good faith.
Although, you might also argue that use of the word unsettled, as Judge Usman quoted from the opinion, was a strong indicator of how the court thought a new request should be considered under the good cause standard.
It could, but again, the court spent quite a bit of time talking about what analysis needed to be applied by the trial court on the remand. And I think that if there had been a finding that this was an unsettled or potentially confusing area of law, it might be a strong signal, but it certainly wasn't an instruction, which this court could have given. In I believe it's in Serbaugh, the court reversed the trial court and remanded with instructions to enter an order dismissing with prejudice the amended complaint. So this court often instructs the trial courts what orders they should enter based on the decisions that it makes. That would be appropriate, even if it wouldn't necessarily be appropriate for this court to make a finding of fact, for example.
So this time, in this case, we should do that.
No, Your Honor, and
No?
and here's why.
Okay.
I've got 3 good reasons.
I thought you might.
First, the trial court correctly identified and applied the correct legal standard. It's very clear from the transcript of the hearing and the face of the trial court's order that it understood that this time around it was the good cause standard under section 122C that applied, and not the extraordinary cause section under the other provision. The trial court also understood that a misunderstanding of law does not constitute good cause if the statute's language is clear. And the trial court also correctly applied these principles when it found that the statute's language was clear, considering the facts of this case and decisions by this court, including Groves. There's also a factual basis for the trial court's decision in the record, the second factor under the abuse of discretion standard. In addition to the precedents of this court, the trial court's order focuses specifically on the expert affidavit of Dr. DeLuke that plaintiff attached to her opposition to defendant's motions for summary judgment months before she moved to amend her complaint. Dr. DeLuke's affidavit does everything that Section 115 requires of an expert. He opines about the standard of care. He opines about the alleged breach of the standard of care as applied to the implied consent claim, and he opines about proximate cause. He does everything that an expert would need to do in order for a plaintiff or a plaintiff's counsel to certify in certificate of good faith that there's a good faith basis for maintaining the action. The trial court found this compelling because it showed that the plaintiff knew exactly what was required. They knew that they needed an expert to vet this claim. They had an expert vet this claim, and yet they still didn't file a certificate of good faith consistent with Section 122's mandatory requirements. In her brief, plaintiff also acknowledges that, quote, filing of Dr. DeLuke's affidavit in response to defendant's motions for summary judgment was simply further acknowledgement by plaintiff that she clearly understood the requirements of Section 122. Previously, before both the trial court and this court, the plaintiff had argued that Dr. DeLuke's affidavit was substantial compliance with the statute, that it could be an ersatz certificate of good faith. Now, both the trial court and this court rejected that argument because Myers tells us that Section 122 requires strict compliance. But at the same time, Dr. DeLuke had done all the work that was required. All plaintiff or plaintiff's counsel needed to do was execute a certificate of good faith that said that that work had done, and they didn't do that.
Counsel, let's assume you're correct about, for purposes of argument, you're correct about the informed consent issue. With regard to all of the other assertions, claims in this case that are advanced by the plaintiff, they have been signed off on by an expert saying that it meets all the requirements. Why should the entirety of the complaint be dismissed rather than just the informed consent claim that, let's say it should have, and let's say that it doesn't mean the good faith basis? Why is the rest of it out?
Two reasons, Your Honor. First of all, this court's precedents and the Supreme Court precedents about what happens when you file an amended complaint. It, as my learned colleague acknowledged, it destroys the complaint. The original complaint in this case doesn't exist anymore. It incorporates the original complaint, but it is complete in itself. And Tolliver and Ingram all teach us that a complaint, an amended complaint, complete in itself, that can stand alone, regardless of an incorporation, wipes out the original complaint.
Yeah, so
Gone.
let me ask you on that point, because at one time I know that there was a couple of ways that you could amend the complaint. One is that you could do just an add-on. You're adding on these paragraphs to the existing filing, as opposed to what you mentioned, complete complaint. Is the answer different in that circumstance? I know you've had a complete refiling here. Do you understand what I'm saying?
I do.
So in other words, you file an amendment, that amendment does not stand on its own. You have to understand it with reference to the original complaint. It may add, for example, a couple of factual allegations and a new count.
Right.
But it doesn't restate the original complaint in full. Is the answer different in that circumstance?
I think it is, Your Honor. I think an amendment to the complaint is not a complaint for purposes of the statute, because it doesn't stand on its own. And so I think in those circumstances, given the text of the statute, the sort of surgical precision that Your Honor's concurrence and dissent in Allen suggests is appropriate would be appropriate in that circumstance.
So isn't the example he gives sort of form over substance?
I don't think so, Your Honor, because I think that I think you have to look to what the intent is. You know, if you're amending a complaint, you're adding, and that's what happened in this case. You can put the original complaint next to the amended complaint. That's what I did, and you can go through, and it's shot through with all sorts of changes, additional facts, a new implied consent claim, deletions, assertions, and all that kind of thing. There was an intent to put that amended complaint in place of the original complaint. Whereas with an amendment to a complaint, or a supplement as it might be called under Rule 15, you're just adding on, you're just tacking on. And I understand that we are speaking today in technicalities, and that in some instances, including cases like this, they often have very harsh results. But on the other hand, it would not, as this court observed in Allen, have been at all burdensome for the plaintiff to have attached a certificate of good faith to the amended complaint. They certainly intended to. They said in the complaint attached as Exhibit 2 is our original certificate of good faith, which we incorporate by reference, but they didn't actually attach it, and this court has found that there has to be a document attached to the complaint. Again, a hyper-technical requirement, but not a burdensome one, particularly in this case, when plaintiff had already engaged Dr. DeLuke to review the medical records and opine on duty, breach, and proximate cause in a several-page affidavit that was attached to their opposition to defendant's motion for summary judgment before the implied consent claim was even added to the complaint.
You wouldn't disagree, though, counsel, that insofar as the amended complaint contains allegations, claims that were in the original complaint, that those have been signed off on by an expert as having a good faith basis, and somebody has looked at the doctor's actions insofar as we've got overlap between 1 and 2. That has been signed off on by an expert, right? And there was a certificate of good faith provided in relation to those claims.
That's correct, Your Honor. There was a certificate of good faith, which stands for the proposition that an expert, it is a certification that an expert has reviewed the records and has delivered an opinion that there is a good faith basis for moving forward with the action.
Is there any language in the statute itself that suggests that the expert is actually supposed to review the complaint. And in looking at the statute, it looks to me like the expert's supposed to look at the medical records and make a determination of whether it meets certain requirements. Is there any language you can point us to that would suggest the expert's actually supposed to read, in the statute itself, that suggests the expert's supposed to read the complaint?
My time is about to expire. May I answer your question, Your Honor?
You may.
Thank you. No, there's not. The case law is pretty clear. The statute, I think, is clear on its face that the expert's only required to review the medical records. But why that's important in this case is that there were medical records directly tied to the implied consent claim that were pled into the amended complaint that were not in the original complaint. There were documents that were part of the basis for this new claim. So looking at all of the different facts that have been alleged, they're not just facts that don't have any relationship to the materials that the expert would need to rely on in order to render an opinion such that a plaintiff could sign off on a certificate of good faith. This new implied consent claim is based on medical records. And before this case was dismissed by the trial court, there was an implied consent claim in this case that had not been vetted. We know that it had been vetted, but that vetting had not followed the procedure outlined in the Act. So given the statute's language, and given what plaintiff knew when they filed their amended complaint, based on this court's precedents and also their engagement and consultation with an expert, there was not good cause here. They knew what they needed to do, and they just didn't do it. And that has harsh consequences, but they're the consequences that are required by this court's precedents and the Healthcare Liability Act. And for all these reasons, we ask that the trial court's order be affirmed in all respects. Thank you.
Thank you. Mr. Cole? Mr. Cole, what changes were made in the second complaint relating to the other causes of action?
Your Honor.
Were they substantive? Were they?
Sorry.
Were they just minor facts, correcting commas? What?
Your Honor, I was not involved in either the first complaint or the amended complaint, and I'm sorry.
Fair enough.
I don't think there were substantive changes. But what's interesting was the whole purpose of the statute was to make sure that this part of the statute was to make sure that an expert would sign off on it and said, yes, there is a cause of action here. And when we filed an amended complaint and they filed the motion for summary judgment, we gave the affidavit to them, say, look, this is what the doctor said. And it was like, oh, no, technically you didn't do it because you had to file that with the amended complaint. The statute does not say you have to file it with an amended complaint. It says you have to file it with a complaint. And that's what we were thinking of, that it went with a complaint. But, I do take issue with my learned colleague that I didn't say we agreed that the amended complaint destroys the other one. I was quoting what they were saying in the previous case. This is not necessarily settled law because there's cases coming up in front. I believe in the dissent there's like 4 cases they had talked about, and it's different things. Sometimes they change a defendant. Sometimes it's a totally new cause of action. But this is not a substantial change here, and it was substantially complied. And if the purpose of the statute is to make it easier for these cases to go through court, then kind of hitting these technicalities like this, and I understand it's a technicality and it's important, but the court is one that decided that it's also for an amended complaint, not the legislature. The legislature doesn't say that. And so if the legislature wanted to say that for an amended complaint, I think the legislature should have said that, but they did not. So we asked, like I said, we just want to get in court. We want to get justice for our client, and what we want is for it's one of 2 things. We can go ahead and find that we had good faith, because I think we showed that we had good faith, in that we put in there that we amend that and add the strictly good faith from the other. And I think that when we showed to the other side, I'm sorry, Your Honor, I'm out of time. Thank you.
Thank you. Thank you both. Would you call the next case, please?